Good morning. My name is Annalisa Suarez-Franco from FIAN International, and we welcome you to this briefing, virtual briefing called Ongoing International Court Advisory Proceedings and the Legal Principles on the Human Rights of Future Generations. Today, we would like to call your attention to the recently adopted Maastricht Principles on Human Rights of Future Generations, which are part of the series of the Maastricht Principles adopted along the last decades, including, lastly, also the principles on the extraterritorial obligations of states, especially with the view to ongoing international court advisory procedures. And for that, we have a very selected group of panelists, especially to present about the influence in the proceedings in the International Court of Justice, the Inter-American Human Rights Court, and ITLOS that has some hearings happening this week. And of course, some states have pleaded and referred to future generations, but we are here not only speaking about future generations, but about their human rights. And on that, the Maastricht Principles are really relevant, not only because they will ensure that we have legal coherence between different legal proceedings, but also because they set very clear principles that can be applied not only in the definition of cases, but also when courts decide, for example, to advise states on developing legislation. So for this, I would present a little bit our agenda for today. We will have a setting the stage presentation of the advisory proceedings and the relevance to the human rights of the future generations. That will be held by Annalisa Savaresi, a professor of the Stirling University and a regional director of Europe for Global Network for the Human Rights and the Environment. Then we will continue with WY4CJ intervention, international justice, and the advisory proceedings. Each time I will introduce the different speakers and a bit their bio. We will then hear an introduction to the legal principles process and to the relevance to the ongoing legal and judicial developments. That will be done by Professor Fons Coomans from the Maastricht University, who is also founding member of this initiative. And then we will have also a presentation of the principles, more on the content, done by Ashfaq Khalfan, who is the Director of Climate Justice at Oxfam, America. So with this short introduction, I would like to give the floor to Annalisa Savaresi. Annalisa is the director of the Europe of the Global Network of Human Rights and the Environment, associate editor of the Review of European Comparative and International Law, and member of the IUCN World Commission on Environmental Law. She is also a professor at the Stirling University and associate professor at the Center for Climate Change, Energy and Environmental Law, University of Eastern Finland. And she has given evidence to the UK, the EU, the Scottish Parliament, and sits on the Board of Environmental Standards Scotland, the body scrutinizing Scottish public authorities' compliance with environmental law, established by the UK withdrawal from the European Union. So Annalisa, please go ahead. You have the floor.
Thank you very much, everyone, for having me here and for this kind introduction. As our chair explained, my job today is a difficult one because I have to provide you with a quick introduction to advisory proceedings before international courts concerning climate change. As we will see in this brief excursus, there is actually 3 ongoing advisory proceedings before international courts concerning climate change. So there is a lot of ground to cover. But with apologies for stating the obvious for those of you who know already, but advisory proceedings are part of the job of international courts and tribunals. So at the international level, there are courts, there are tribunals, not all of them can engage in advisory proceedings, but many of them do. It's a parallel function that they provide together with the most obvious one, which is that to resolve disputes. Advisory proceedings are not about resolving disputes between state A and state B. Instead, they have a function of clarifying and interpreting the law, which is also something that courts do all the time at the national level, at the regional level. The Court of Justice of the EU does this all the time. They basically tell states what the law is and what the implications of their obligations are. This has happened a number of times throughout history, so it's not new. It's not happening now for the first time. What is also important for us to appreciate is that, formally speaking, advisory proceedings, what the courts say in this proceeding, is not, technically speaking, legally binding on anyone. And yet, of course, the point of the proceedings is to clarify and interpret the law. So it is important. It's quite a solemn process, as you will grasp from what I'm going to describe to you now, where states and non-state actors engage in order to influence the courts in determining what the law is and what the correct interpretation of the law is. Once they are concluded, these advisory proceedings deliver what is called commonly an advisory opinion. And this advisory opinion lives a life of its own. Some of these advisory opinions have been very influential, some of them less. There is a very interesting podcast of the European Society of International Law for those of you who are interested, where past advisory opinions have been discussed. And I invite you to watch it because it's really good. But what I would say is that there is two main effects of advisory opinions. One of that is to influence state practice. So states do interpret the law in the way which the court said it should be. So as we will see, there is a number of questions now before international courts concerning climate change of a practice in this area will be informed by these advisory opinions once they are delivered. The other very important aspect is that to influence the practice of domestic courts, national courts, regional courts, like the European courts. And this is really important because it's through this judicial practice that the interpretation delivered in advisory opinions becomes alive. So what advisory opinions are there? As was already mentioned earlier, there is this week and next week hearings ongoing before the International Tribunal for the Law of the Sea. This is a special international law tribunal that has been created under the United Nations Convention of the Law of the Sea. And the tribunal is conducting hearings now. It has already concluded a process of eliciting submissions. This tribunal has received submissions by states, but also by NGOs. CL has made a submission together with Greenpeace, IUCN, WWF. A number of subjects have made submissions. And you can watch the broadcast live or look at the summary that Seb publishes every day, as he normally does, very efficiently, summarizing what has been said during the hearings. The questions before the court are very specific. They concern the law of the sea, and therefore what the applicants have asked of the court is really to clarify the obligations of states in relation to two main things. The first one is the obligation of states to prevent, reduce, and control pollution of the environment marine environment, of course, from climate change. There is an obligation under the United Nations Convention of the Law of the Sea concerning the protection of the marine environment. So what the parties really, the states that have asked the advisory opinion, what they really want to know is, what do these obligations mean vis-a-vis climate change? In other words, what do states have to do in order to discharge their obligations associated with marine environmental pollution associated with climate change? And a similar but different question concerns that of the obligation of states to protect and preserve the marine environment in relation to the impacts of climate change, such as warming or sea level rises. So these are two related but distinct matters, and the ITLOS will deliver its advisory opinion on these two questions. Then there is, if you like, the most important international court of all, the International Court of Justice, that was created by the UN Charter a number of years ago now. So the oldest serving international court involved in advisory proceedings on climate change. Not everyone can make submissions to the International Court of Justice. The International Court of Justice is receiving submissions on this advisory opinion from the bodies that are listed here, or rather it has authorized the actors that are listed on this line to provide a submission. The deadline for submissions is the 22nd of January, so there's still a bit of time. The deadline was extended to everybody's relief because, as you may appreciate, it's been the most important international court. There is quite a lot of pathos associated with it delivering an advisory opinion on climate change. What are the questions before the court? The questions before the court are not limited to one instrument of international law, so the parties really asked the court to clarify the obligations of states under international law generally concerning the protection of the climate systems. And this is really quite broad potentially, involving the climate treaties, but also a number of other treaties. What are the legal consequences of these obligations for states with respect to small island developing states on the one side, and peoples and individuals of present and future generations, therefore linking to the Maastricht Principles very neatly here. So we are looking at the subjects that are sitting on the blunt edge of climate change for small island states, developing states that are suffering the most severe consequences of climate change already, and the generations that are going to be most affected. It's important that we note that both this advisory opinion before the ICJ and the advisory opinion before the International Tribunal of the Law of the Sea were promoted by small island developing states. In a remarkable exercise of leadership, these small island developing states have managed to summon support from a number of parties, especially at the UN General Assembly. You cannot bring an International Court of Justice request for an advisory opinion without broad support at the UN. And these small island states have managed to do just that, showing remarkable leadership in international relations. Now, the last opinion that is also very important for the purposes of this group is that concerning the Inter-American Court of Human Rights. The Inter-American Court of Human Rights is one of those international courts that is specialized on matters concerning human rights. And in this connection, it too is considering a number of questions that are put to it by two members of the Inter-American system. The interesting bit for you to know is that any person or institution can make a submission to the Inter-American Court. You can see the details on this slide. The deadline is coming up soon. The Inter-American Court has been called upon to answer a very articulate series of questions concerning the right to life, but also the rights of children, as well as, of course, the rights of specific groups like indigenous peoples, environmental defenders, and to articulate states' common but differentiated responsibilities in the context of human rights and climate change. So what are states' obligations here? What are their responsibilities? Because as you may appreciate, the Inter-American system is made of a variety of states with different levels of development and responsibilities for the climate crisis. And the Inter-American Court has been asked to provide an advisory opinion on this matter. So I think I have already exceeded the time allocated to me, and I hope that I managed to do what I was asked. But please feel free to ask any questions you may like, and I will try and answer them in the Q&A. Thank you so much for having me today.
Annalisa, thank you very much for this explanation. I think it was very clear what you pointed out, that there is a need for clarification, for interpretation, for guidance, for states, for courts. And this is especially needed when we are facing at least the three environmental planetary crises. Therefore, very pertinent the guidance by the International Tribunal of the Law of the Sea, especially on view of the plastic crisis, but also what is happening with aquacultures, mining in the sea. And we need to know, we need courts to clarify how this, how impacts on the human rights of future generations would be affected. Similar, you mentioned for the International Court of Justice, especially the plea of the small islands, very important. We don't know if they will have future generations, if they disappear, or if they are so salinized that they cannot produce food. And finally, the the Inter-American Human Rights Court, which has been very leading internationally on progressive jurisprudence. And we are very curious to see also how the obligations will be interpreted, especially taking into account the intra and intergenerational justice. So thank you very much for that. And then we can go to our next speaker from the WY4CJ. We have Aditi Shetye, who is an academic coordinator of the World Youth for Climate Justice. So this is the WY4CJ, and she's an environmental lawyer and works as the academic coordinator for this youth movement. Also, her research focuses on climate change law and the environmental law, and many other things. I will make the story short. We are very happy to have a young person here who can also explain us a bit about their view on the issue of intergenerational justice and how it's seen by these movements. So, Aditi, you have the floor. Thank you.
Thank you so much, and thanks for the very kind introduction. And I'll be sharing my slides and starting soon, yeah. Thank you for having me. Thank you, Seth, Camilla, Ciel, for inviting me to the panel. I'm very happy to be presenting on behalf of WYCJ today. Diving right into my talking points is that Seb requested me to intervene on 3 points, mainly one, the role of youth in the advisory proceedings, specifically the ICJ-AO. 2, what intergenerational justice means to us as youth. And lastly, our message on intergenerational justice in the context of all the advisory proceedings. This is basically explaining the existence of WICJ and probably even PIFCC in 10 minutes. So I'm going to try my best to stick to the time. And to address the first question, I will start with presenting what WICJ and what PISFCC, what our work has been since 2019. The World's Youth for Climate Justice is a youth-led global campaign to take climate change and human rights to the ICJ. We seek to influence states to protect the rights of present and future generations from adverse effects of climate change. We focus on the operation of the principle of equity, specifically intergenerational equity within the international legal sphere to achieve, with the aim of achieving climate justice. When we realized that this initiative to succeed has to go beyond the Pacific, that's when WICJ was founded. The aim was to build a global campaign in support of the diplomatic efforts of Vanuatu. And we therefore have localized a campaign in Asia, Africa, Caribbean, Europe, and even Latin America. With this in 2002, we also formed an alliance of around 1,500 CSOs that helped us push this initiative forward. However, I think there is massive acknowledgement on our part that this initiative stands on the shoulders of the past attempts made by Marshall Islands and Palau in 2011. And I don't think I can proceed without acknowledging the support and the leadership of the government of Vanuatu, who is seeing this initiative through. We also realized that we had to work with the governments and use diplomacy to our benefit. I think this was a learning curve for us, and how to play a role in high-level proceedings, especially working in sync with Vanuatu that championed the whole initiative through the UNGA, as Professor Savaresi mentioned earlier, and the effort that it took. Now, considering all the advisory opinions that are going on, we have branched out into the other AO movements. And to that effect, we have published the Youth Climate Justice Handbook. The handbook is, the purpose of the handbook is to engage as many states as possible, but also other stakeholders, just like the IUCN, CL, Greenpeace, etc., which have, like, for the first time, it is unprecedented that they'll be making submissions to the ICJ. And another important targeted audience of the handbook was climate vulnerable states, to address specific principles or specific issues that are highlighted in question 2, which are related to intergenerational equity and protecting the rights of the most people that are vulnerable from climate change. Now, moving on to the second point and holding our ground on the issue of intergenerational justice as a key element, it only made sense for us to focus on the point of intergenerational justice, given the dire situation that we're in, and relying on the clear evidence that is pointed out time and again by climate scientists, that the impacts of climate change are not only affecting us presently. Any act or omission that is being carried out right now is going to have consequences in 50, 100, and possibly 200, 300 years down the line. Out of that, youth, children, and the generations that are to come, that will inherit the planet, it will be in a catastrophic social, environmental condition. And to address that, it is important that we need to swiftly and ambitiously address and work around these issues. So we as youth find ourselves fighting for intergenerational justice. It is not just for reparations from the past, but if I may put it this way, it is for pre-reparations for the people that will live in the next century and the centuries to come. So it is needless to state that irreversible climate impacts are disproportionately going to affect youth and will continue to do so in the future. Now, putting this in the context of climate litigation, there have been multiple scenarios across the world that are challenging this linear concept of human rights violations. Right from the Okosa case, the Juliana case, the Torstrediden case, the GNHRE case, Goa Foundation, Neubauer case, and many more, and even the most recent Montana case, we see that there is legitimate recognition of the rights of future generations. But it is also important to note that the instances where regional and domestic courts in the global south have delivered this kind of jurisprudence, recognize this principle, it is noteworthy because it is often the case that these jurisdictions lack the resources to implement these decisions. However, this concept, for it to work, for it to actually be implemented, it has to go beyond recognition. It is important for it to be imbibed. It is important for the principle of intergenerational equity to be imbibed along with other fundamental rights. So this has to be interpreted not only through judicial systems, but also within hard and soft law. Now, intergenerational justice could perhaps be achieved through instilling intergenerational equity in human rights framework. And now there is consensus that the intergenerational framework has not only recognized, but also emphasized it in many of its latest covenants, that is the General Comment 26 of CRC, the Maastricht Principles that we were talking about today, and so on and so forth. But from a public policy perspective, I think the Maastricht Principles very rightfully embody this, is that there is an obligation to provide effective remedy. These principles recognize that children and youth are temporally close to future generations. Thus, the need for them to be included in decision-making is pertinent to protect their rights. However, again, going back to the point that these covenants mostly are soft law, there is an urgent need to have them integrated into hard law. And as Professor Savaresi very rightfully explained, that how the effects of the AOs are going to take forward, they're going to be, they're going to influence domestic judicial practice, they're going to influence state practice. So I think this AO is an opportunity for the International Court of Justice, again, as rightly said, one of the most important international courts, to clarify the content and scope of the principle of intergenerational equity and perhaps intergenerational justice. Now moving on to the final point, and I will close with this, is that what is our message? What is the message from the youth? What do we want? We want many things, I think, but for now, it is safe to say that we're looking for a progressive and forward-looking advisory opinion on these kind of state obligations. As of now, we are calling all states, especially climate vulnerable states, to make forward-looking submissions and use the existing international law creatively and in the interest of future generations. We want to see the AO integrate the rights of future generational and intergenerational equity from a climate change context within the human rights framework, hard, soft, within state practice, within domestic jurisdictions, and its implementation. We want the AO to interpret state obligations in consideration of the disproportionate adverse impacts of climate change on youth, minorities, and indigenous people. We would like for the AO to elaborate on the legal consequences in cases of violations of these state obligations. And then finally, we would also like to have a seat at the table, at the decision-making table, to ensure that our rights are protected. I do understand that a lot of this is very ambitious, but at the same time, I think I'll stop there, and I will be happy to get more questions on this in the interest of time. So thank you so much for having me, and I'm going to stop sharing.
Thank you very much, Aditi. I think it's, as I said before, it's very important for us to have you developing a bit on how the youth understand the intergenerational justice. Maybe when Ashfaq and Fons speak, they will also come to the intragenerational justice, and especially also the importance of this creative work of the courts, looking in what we are facing for the future, and especially you and children and those who are going to be born. We need obligations to be clarified that should not be only framed as solidarity, and in some recent UN documents from the General Secretariat, obligations that therefore have accountability mechanisms, and you also emphasized on that. So thank you very much. That shows how important participation of youth people is. And now we will go to Professor Fons Coomans, who is the professor of the Maastricht University and founding member of this initiative on the rights, human rights of the future generations. He held the UNESCO Chair in Human Rights and Peace at the Department of International and European Law at the Faculty of Law at the Maastricht University until September 22. So last year, Fons retired, but is still very active in our initiative. And he is now an emeritus professor and has been the director of the Maastricht Center for Human Rights, which was the one of really impulsing all these Maastricht Principles initiatives. Fons is also part of the Dutch section of the International Commission of Jurists, and therefore also a very, very respected voice in the field. And Fons, thank you very much for being here. Since 2017, we have been working together on this initiative, and you will be invited to present about the process and also the key milestones of this short history of the Maastricht Principles.
Yes, thank you very much, Anna. Indeed, as you already said, I want to give a little bit of background of how this process of developing the Maastricht Principles developed over the years. Indeed, we started back in 2017 when FIAN, represented by Rolf Kuneman, the Human Rights Director at the time, and Maastricht University brainstormed and thought it would be good and very topical to address this issue of the human rights of future generations, in particular against the background of climate change and other loss of biodiversity and other dangers to the survival of people and the planet. So we joined forces and we asked CL to join, and they did. We are very thankful for this, but also Lancaster University, represented by Sigrid Skakli. So we started in 2018 by bringing a number of people together, and that was before COVID interrupted our work. So we were able to have a number of physical or in-person meetings. The first one, I think, was in Heidelberg, and later one in Geneva, just before COVID broke out in early 2020. And we thought, well, this is the right moment for initiative to clarify from a legal point of view the human rights of future generations. Because we came to the conclusion that there was a need to clarify those rights from a normative perspective in terms of what are these rights, what are the obligations of states, how should we address issues of accountability and remedies. So the initiative is similar to earlier Maastricht documents that were adopted under the auspices of Maastricht University, which go back to 1986 when we clarified the International Covenant on Economic, Social and Cultural Rights. Later, there was an expert opinion on violations of economic, social and cultural rights. And in 2011, the well-known principles on the extraterritorial obligations of states in the area of economic, social and cultural rights. So this recent initiative, which is called indeed the Maastricht 4 initiative, very well fits into that series of expert opinions, because indeed we are talking about expert opinions. Experts being people with a legal background, people from NGOs, civil society, some UN representatives have been involved, and some former UN special rapporteurs. So the idea was to bring together these people and brainstorm, think, but also in particular write and draft an expert opinion on the human rights of future generations. So we set up an online a tool which is called Basecamp, where people were able to comment on work that was done by different working groups on thematic issues, such as on obligations, on legal standing of human rights on future generations, issues of accountability, remedies, etc. And we were able to discuss these preliminary reports during the Geneva meeting in February 2020. And from that moment, we were blocked in a way by COVID, so we had to decide to continue the work, mostly online, through online meetings and consultations. And we had several online consultations, including with academia, with people from civil society, NGOs, youth organizations, some people from the UN have been involved. And after 1 year, so in the summer, fall of 2021, we decided, well, this is the right time now to establish a drafting group composed of experts who had the task of laying down in writing the rights of future generations, very similar to the earlier Maastricht documents. And that's what we did. And let me just mention the people that were in that drafting group. One person is joining us today, that's Ashfaq. And the committee was chaired by Professor Sandy Liebenberg from South Africa. We had Magdalena Sepulveda, we had Milun Kotari, we had Sharon Venne Many Fingers, and we had Margareta Wewerinke Singh, and finally Carol Muffet from SIA. So 7 people working very hard to draft a text through different stages. And it's interesting that all those drafts have been subject to consultations, online consultations mainly, and also regional consultations organized by FIAN and SIA. And finally, we were able to have an in-person expert meeting, which took place earlier this year in February, where we were able to adopt, but also to finalize through 3 very intense days of drafting, commenting in Maastricht, the principles as we know them today. And since February of this year, the principles have been published, but also have been circulated internationally through a number of online consultations, but also through 2 presentations, one in Geneva as a side event of the Human Rights Council meeting, and one in July in New York, also as a side event of the United Nations General Assembly. So I think we have been successful in adopting an interesting text, which Ashfaq will explain in a minute. And it is important also to mention that many people have endorsed the text so far. Of course, those who were members of the drafting group, those who were present in Maastricht at the expert meeting, but also some 50 people more who have endorsed the text as it is today, human rights experts, scholars, representatives of NGOs and civil society organizations. And it is important to show that the document as a whole has been widely welcomed and supported by many people. Indeed, Seb is now mentioning in the chat that there is a special website where you can download the text of the principles. And finally, before I conclude, it is important to mention that in addition to the principles, a legal commentary will be prepared, will be finalized in the course of this year and will be published in one of the leading academic human rights journals, which is the Human Rights Quarterly. So the text of the principles, together with an extensive commentary drafted by the drafting group. So I think I'll stop here. Thank you.
Thank you very much, Fons, for explaining this way, and also how experts were involved, but also social movements, and therefore it was a difficult task. I remember when social movements were asking, okay, but how or why do you concentrate in future generations if in the present generations we have so many groups that are oppressed and discriminated, and how is that with present and future and the continuum? So very difficult questions that our drafting group was able to solve in a brilliant manner. And for to go into this content, I am sure you are already curious. We have here our colleague Ashfaq Khalfan. Ashfaq is the director of the climate justice at Oxfam, and he was previously director of law and policy at Amnesty International. Prior to working at Amnesty, he was the head of the Right to Water program at the Center for Housing Rights and Evictions, GNHRE, and also a founder and director of the Center for International Sustainable Development Law. So also a very qualified person. And I just give you the floor, Ashfaq, to tell us what is in the principles. Thank you very much.
Great. Thank you very much, and thank you for inviting me, and thank you for everyone who's joined. All right, so I'll share my screen with some information on this. All right. I'm qualified at some things, but PowerPoint is not my strength. So I'm trying now. And Annalisa, Anna Maria, is it visible? Okay, great. Okay, so I'll cover the legal basis and some of the content of the principle. Now, the principles are really, really detailed, about 26 pages, and so I won't cover that all here. And of course, it's much broader than climate change. It covers the whole gamut of rights. Now, one thing to emphasize is that we're not standing just on the backgrounds of the drafters or the commentators. The principles are based on existing law, so they're based on the whole treaties and the general comments of a whole range of treaty bodies, and we've tried to distill that to explain what that means for present and future generations. Now, one really important point, of course, is there is a debate on whether future generations actually do have rights. So we dealt with that in the principles, and there are three bases that I want to cover. The first is in human rights treaties, and as the principles make clear, human rights treaties talk about achieving rights universally for all people, and they're never limited to present generations. It doesn't say that only people who are alive now at the present have these rights, and in fact many of them they talk about preventing future generations from the scourge of war. That's the language in the UN Charter. Very much the intention is to change humanity rather than serve as a set of entitlements for a specific group of people. So in the drafting record of the treaties, you can see the drafters are trying to create a better society and better humanity moving forward. It's very clear. So anybody who's talking about limited present generations is actually reading in text which is not, or intentions which are not actually in the treaty. Several of the treaty bodies who have the mandates from states to interpret these treaties actually reference rights of future generations. The UN Human Rights Committee, the Committee on Economic and Social Rights, in fact, the Inter-American Court of Human Rights. I mean, not all treaty bodies consistently do that. I mean, but enough of them have done it to indicate that there is a credible case for reading these treaties in a way that applies to future generations as well. When you look at what states have said, including, as I think was referenced, the General Assembly and Human Rights Council, when they recognize the right to a healthy environment, they recognize that climate change constitutes one of the most serious threats to the ability of present and future generations to secure their human rights. So not just, not talking just about present generations, but clearly recognizing that future generations also have rights. The Rio Declaration on Environment and Development talked about the right to development, for example, being realized for both present and future generations. These are a few examples that we hope the international courts will look at treaties in that light. So that's in terms of how one reads human rights treaties. Then there are a wide range of instruments where states talk about obligations towards future generations and the need to ensure intergenerational equity. Now, these are all statements, this legal second basis, this is outside of the human rights context, but it's distinct. This is when states aren't talking about rights; they are talking about obligations. In different regimes. Now, so the examples, and there are, almost 50, 60 treaties that say this. But a few examples: the UN Convention on Biological Diversity, the Convention to Combat Desertification, both talk about the obligation to take measures for present and future generations. The same for the World Heritage Convention, recognize the need to transmit cultural heritage to future generations. The UN Framework Convention on Climate Change talks about protecting the climate system for present and future generations. Paris Agreement also has that in the preambles. I'm pointing to treaties that have close to universal recognition or close to universal recognition. So these apply to all states. Then, of course, the Court of Justice, the International Court of Justice itself has said that states are not, obligations not limited to present and generations, but also apply to future generations. There's a very broad statement in the Gapchi-Kofel case, for example, or the advisory opinion on the threat of nuclear weapons. So there's quite a bit of precedent there that can be applied. So all of these are, although they're not specifically about human rights, they're relevant rules that, according to the Vienna Convention, when you're interpreting treaties, you look at other rules that apply between states. So the third is general principles of law. General principles of law is a recognized source of authority in international law. Excuse me. And is intended to reflect principles generally in national laws that are so common as to be treated as binding internationally, not just nationally. Now, one of the things we've done when we're analyzing this is to look not only at traditional formal law, written codified law under existing systems, but also cultural values, and for example, and in fact, indigenous laws themselves, even though they are not, UN member state laws, there are a range of them for a whole range of indigenous people. Now, we've not surveyed every single indigenous people; that's impossible. In every single religious tradition, we've looked at examples, but we've seen quite a bit of commonality there. Although, it would be wrong to say that every single faith talks about future generations, but many of them do. And the national law, in probably most countries, there is language either in the constitution, 70 constitutions on intergenerational justice, equity, or legislation. For example, even in the United States, the National Environmental Protection Act, which has actually been used as a model for many other legislations in other countries, recognize the need to fulfill the economic and other requirements of present and future generations. Then even in many places where the future generations are not recognized as having entitlements or rights in constitutions or laws, it's been interpreted by the judiciary. The famous Minors of Posa case in Philippines, for example, many cases in Pakistan. So you take all of this together, and actually probably just the first basis that I indicated would be enough, I think, to apply human rights treaties to future generations. But these are additionally just to supplement the authority for that. So with that, the principles take the view that the whole corpus, all international human rights treaties, instruments, custom, apply both to present and future generations. And so then the principles then talk about what that means in terms of the obligations to respect, protect, fulfill. So in each of those, the principles talk about the rights of present and future generations, and in many cases there's a commonality. In order to achieve future generations' rights, you actually have to achieve the rights of present generations. So the principles give examples. It doesn't try to be comprehensive, but it gives examples. So of the need to protect natural resources, to phase out emissions, to change unsustainable patterns of consumption and production, all of which are necessary to protect the climate. On participation, we needed to obviously there is the challenge that future generations aren't there presently to participate in decision making. So the principles do two things. Number one, talks about a variety of mechanisms by which states can make sure that the rights of future generations are represented. There is no one way of doing it. There are many different ways, be it a commissioner, be it a parliamentary committee, be it National Human Rights Commission. That's up to states and societies to decide how to represent the rights of future generations. But what is important is that it is taken into account, and there's a concrete representation of their rights, of people who have a mandate to do that. So that's the first. The other is to recognize, and Aditi said this, I think, that youth are proximate to future generation. They're not the same as future generations because they're existing. They have their own rights as members of society. But additionally, they have children's rights, which are specifically codified. But they also have a perspective and are closest to, and so should be taken seriously when they choose to represent the rights of future generations. They don't have to. They may not want to. But if they do, they have that perspective, which is particularly useful. Then on remedy, the same applies, that those with the mandate to participate on behalf of future generations also have the right to seek the remedy, and that should actually be taken into account. Now, there are 2 points that I just wanted to touch on before we close. One is the question has often been asked, well, what difference does it make? We can just protect the rights of present generations, and in effect, that will protect the rights of future generations. And it's an interesting criticism. It's maybe not so relevant for the legal point of view, because if actors have rights, you have to accord them, whether or not you feel they have a value add or not. But there are a couple of factors. One, it's just the time scale. And here I'm actually drawing on text from the principles, that the resources, if one could figure out ways in which governments together use up resources over the course of the next 80 years, leaving nothing for generations to come after that. So that has to be taken into account. It needs to be factored in, particularly with non-renewable resources that we draw on. The second is the burden of responding to future generations. As the costs get higher, a lot of governments have been doing that, really postponing and postponing and postponing. And that was actually the basis of the Neubauer case in Germany, where that was one of the specific bases under which the government was told you cannot do that because you are transmitting the burden. Another is the cost benefit calculations that governments are constantly doing that. They constantly have to weigh the cost of acting versus the potential harms. And if as is done in many cases, the harm to the future is discounted, is not taken into, is treated as having lesser value, that then changes the way we act now, and it causes harms to future generations. Anna Maria really wanted to cover this point, which is there could be a concern that, are we going to protect future generations at the expense of present generations? And you actually have to do both, because if you don't accord to present generations their rights, that disadvantage is going to be transmitted to future generations. Everybody knows that. If it'll affect children and the conditions in which they grow up, and the way in which privilege and resources can be transmitted to future generations. So it's a false distinction. It would be a false distinction to say that these are distinct. It would be but it would be important, though, to talk about the ways in which these two rights should be accorded. It's not right that it wouldn't be correct to say that present generations, can do everything they want and future generations can do everything they want. There have to be some reasonable restrictions on activities that undermine the rights of, both present and future generations. And the way to do that is to ensure that the disproportionate use of resources by some over others has to be addressed with. And I hope that the courts will be able to go into that level of detail, because it does actually require very specific changes to the way in which power and wealth are allocated in society. Human rights courts tend to be, even treaty bodies tend to not want to actually set it out in such stark, almost political terms, but that is the inescapable reality of what has to be addressed. The last point is just to also point to the fact that the addressing climate change will impose costs and burdens, and it's important that those are borne by those states, the groups that have the ability to address that. This is, human rights treaties tend not to say that, but that's the logical conclusion of applying the principles of non-discrimination, priority for marginalized groups, to the actual concrete situations that we deal with. So I'll stop there. I've not gone into the principle. The principle, of course, have a lot more detail about what the challenge of climate change means in terms of present and future generations. I'm happy to address questions. Thank you very much.
Thank you very much, Ashfaq. And yeah, this is a quite difficult task to summarize so rich principles, which in any ways, as you have shown, are a good guidance on how the interpretation of the law should be. I think all the examples on possible violations, also going into toxic substances, nuclear weapons, are very useful for the court on view of the risks that our humanity is living today. Very important also the mention of the precautionary principle, which of course is a tool that courts have, and that more and more human rights courts are applying, imported from environmental law, similar to the principle of common but differentiated responsibilities. So very relevant. I would just like also to highlight that you included in the principles also clear rules on representation. One of the fears of many was that we end up again having a representation that is very traditional, normally people from the north, patriarchal systems, and so the principles are also very clear on how the different groups affected should be represented. And this is important also when the courts will receive claims. So with these words, I would like to finish here my part moderating the panel. It was a very rich panel, and of course there are already very interesting questions in the Q&A. I will now pass the torch to Joy Chaudhry, who will support us with the Q&A. Joy is a senior attorney at the Center for International and Environmental Law, CIEL, one of the organizers of the event. And she is the perfect person for this role because she is coordinating the engagement of CIEL with relation to the advisory procedures. So, Joy, it's a pleasure to let this interesting event in your hands. Thanks a lot.
Thank you so much, Anna Maria, for your brilliant facilitation. And thank you very much to the panelists for this very insightful presentations. This is such a timely discussion. As we've seen from Annalisa's great presentation, that the questions of future generations is actually embedded in the very questions presented to the courts. And also, as we have seen during the Int'l hearings, the hearings before the International Tribunal for the Law of the Sea, states are bringing up the questions of future generations as well. So the Maastricht Principles are such a timely and brilliant contribution to the normative development of the legal field. And we have some very key experts here today. So we really encourage you to ask questions in the chat. And we will turn now to the questions that we have received already. So there has been a conversation going on with Annalisa and Leanne Sackett on a very important procedural questions on whether the UN can submit, can make written or oral submissions in relation to the legal questions. And I think Annalisa has already responded in quite a bit of depth, and also the ICJ has given clear guidance on this, on the procedure of how international organizations can come in both on written and oral submissions on the legal questions. But Annalisa, would you like to further add anything to the written responses?
Just briefly, that a lot of the practice of the past on advisory opinions is very technical in nature and concerns the functioning of international organizations themselves. More fractious, politically loaded questions like the one that is presented before the ICJ are relatively rare. So we don't have a lot of past practice to go by. So when you look at the submission of the UN Secretary General, for example, in the connection of the Palestine war, a political issue, if we want to label it as such, you can see that the UN Secretary General produced a lot of statements of fact on reports compiled by UN agencies. He was very careful in being factual. This is a different subject matter altogether, and I can see that the UN Secretary General, of course, provide a lot of factual basis. I understand that there is reluctance within UN bodies to do more than this, but I don't think there is any formal limitation, if you ask me, on UN agencies here. It's just a matter of their own political will to jump that obstacle. So let's see what happens. There's still time.
Thank you very much, Annalisa. And just to note that the UN tends to provide consolidated input. So for instance, like the UN Environmental UNEP intervened separately at Int'l. They may not do that at the ICJ. But I agree with Annalisa, there aren't any clear limitations from the written guidance of the ICJ on how international organizations can intervene in the proceedings. Seb, did you want to come in? No, okay. All right. So to move on to another question, I'm going to go back to the one that Professor Coomans received. I know that you've already responded to that, but I think it's a really important one for the rest of the group to hear as well, and all of the attendees, on how we can apply the Maastricht Principles as instruments to argue for the responsibility of states to apply specific measures for the rights of future generations. Professor Coomans, if you could come in. Thank you.
Yes, thank you. If NGOs or civil society organizations or social movements are really concerned about the rights of future generations, and they are in contact with governments, then I would advise indeed to use the principles as an authoritative document, not legally binding as such, but it reflects the law as it exists today, in addition to some progressive development of the law. So you could show to your contacts, to civil servants and governments, how these rights of future generations have been interpreted in this expert opinion, and that would strengthen, I think, your argument. Because so far, if I'm not mistaken, this is the only document at the universal level that exists that in such detail explains the human rights of future generations. In many documents, there are references to, let's say, the needs of future generations, but not explicitly to rights. There are a few exceptions. I think Ashfaq has mentioned them, but they have not been interpreted and written down in detail. And this is exactly what this expert opinion is doing. So use the principle in detail when contacting governments. Thank you.
Thank you very much. Would any of the other panelists want to comment on this as well, on this particular question? No? All right, then I'm going to move on because there are a number of questions. There is one from Ulysses on whether there have been national cases or jurisprudence recognizing future generations or furthering their human rights. There has been, of course, but I want to open this up to the panelists. I think all of them would be well placed to respond to this. Please come in. Ashfaq, perhaps we would want to throw this to you.
Sure. Yeah. I mean, there's so many. There. I mentioned there's one of the most famous ones was in the Philippines, the Minors Opposer case. There's Colombia, the Constitutional Court there adopted measures to protect against their deforestation account, both present and future generations, and Pakistani cases on water. So there's just very, very many of them. As I said, there are about 70 countries that have intergenerational justice in their constitution. So that's led to cases that maybe we haven't even taken into account. Yeah. So that's one of the bases we say that there are general principles of law across countries recognizing these rights.
Fantastic. And as Professor Coomans said, like the Maastricht Principles builds on existing international law and jurisprudence, and that's really important to keep in mind. But thanks very much for that question, Ulysses, and the responses. Aditi, did you want to come in on this question?
I would just like to add on what Ashfaq said regarding jurisprudence that already exists. There's rightly so much going on, especially within jurisdictions where perhaps this is not explicitly mentioned in their constitutions as well. So I think that's very important to understand in the sense of how jurisprudence has been developing in regional and domestic jurisdictions. So having said that, we do know, as Ashfaq also mentioned, there is legal basis. There is so much international law that recognizes it, emphasizes it, talks about it. There's so much discussion in academia that goes about around this. So it is about actually utilizing it in implementation and going beyond recognizing and emphasizing. There has to be some sort of system where we can work out how this could actually reach the grassroots, how this could actually benefit the future. And as I also mentioned earlier, is that, again, children and youth right now are relatively closer, and they'll be the ones living through this when future generations do come in that do not exist right now. So putting that into like context and putting like against all of this background, I think it does possess like a very unique opportunity, not just to the ICJ perhaps, but also to the Inter-American Court, where, you know, Professor Savaresi said there are so many articulated questions on that. So I think it is just, to me, as a young lawyer, I think it's just very natural that it comes that this needs to be integrated in not just human rights treaties, but also just in fundamental human rights principles. So yeah.
Fantastic. Thank you so much, Aditi. And since I have you on the floor, we have a question specifically for you, which is wanting to know a little bit more about how the handbook addresses the issue of states not having resources to provide an effective remedy for future generations.
Thank you so much for the question. I think that's a very tricky question to answer. So when we decided to make the handbook, we wrote it with not just us from WICJ or PIFCC, but we also consulted academics and we wrote it with international lawyers. So the main purpose and the target was actually to make it so reachable and accessible far and wide that there are so many states that have never had the opportunity to present or come to the ICJ even. And I think this is perhaps one of the unprecedented times where there are the African Union, the COSIS, IUCN, and organizations such as intergovernmental as well as non-governmental have been there. So the handbook essentially was to initiate that from the outside, while there was a lot of this goes back to a lot of political talk about how Vanuatu was leading its diplomacy at the UN level as well. But at the same time, when we elaborated in the handbook, we had to make sure that we keep a very neutral tone, because again, we wanted as many states to come and participate in these proceedings. I think that was like the main goal. And having said that, we addressed the second question very generally, more broadly, and because again, the second question, if I must say, is slightly politically sensitive, because it talks about consequences. It talks about specific consequences to specific regions, specific people. So that does sort of address it very generally. But now I think, having said that there is so much international law, there is so much domestic jurisprudence, I think that just, it would be responsibility of states to tie in all that together. And I think they are in the position to do that as well. So yeah, that's all I would say for the handbook.
Thank you very much. And there are a lot of questions coming in. I encourage the panelists to also respond in writing so that we can be sure to respond to these great questions. But one of the questions I wanted to highlight for the group and all of the participants as well, because the topic of today's discussion is about the Maastricht Principles and how it can play this pivotal role in the advisory opinions, is a question that was addressed to Ashfaq, but I think actually all of the panelists would be well positioned to respond, is to highlight some of the legal basis in human rights treaties for the protection of future generations, and really kind of some of the key arguments we should be thinking about when building an argument on this basis. So Ashfaq, since the question is to you, I'm going to give you the floor, but please come in, Professor Coomans and Savaresi and Aditi. We would love to hear from you as well. Ashfaq? Sorry to put you on the spot.
No, that's fine. You're referring to Andrea's question, is that right?
Yes, you've responded to it, but I think it'll be important for everyone to hear that as well.
Okay, sure. And colleagues, please feel free to come in, because yeah, so the legal basis. So, when you read the treaties, and I've been rereading many of these treaties, there's nothing that says that this is just for present existing living people. It talks about all people, you know, and all humanities. So that's just the you know, the reading of the treaty itself should be read for present and future generations. But the people who wrote the treaty were thinking of future generations as well as present generations. So I put a few sources in the chat. So some of the writing by Cancado Trinidad, the human rights bodies who have the mandate to interpret these treaties, such as, for example, the UN Committee on Economic and Social Rights. So in some of the general comments, like the general comment on social security, the general comment on the right to water, among others, they specifically say these rights need to be realized for present and future generations. So these are the bodies who have been given the mandate to interpret it. They review states' performance, and you know, the Inter-American Court, the advisory opinion from 2017, specifically recognizes. So those are some examples. Then there was a question about religious principles. What I was indicating there was that if you look at many world religions, they talk about obligations towards future generations. So we don't have anything specific about a religion or some religions. We're just saying that these help illustrate this common theme that future generations have rights and have to protect it is reflected through a wide range of sources in society. So it's not just these looking at the treaties and these sources that I've just mentioned, and it's reflected more broadly in society. Thanks.
Thanks very much, Ashfaq. Would anyone else want to come in on this? Some of the legal basis in the human rights treaties for the protection of future generations. Annalisa, you have your hand up. Please go ahead.
So a general observation that is really important for us to make here is that the UN Conventions on the Right of the Child and the guidance that has been issued subsequently, most recently in the context of the General Committee, is really important here because international obligations are not alive until they are implemented and enforced in national contexts. And there is an enormous gap in the implementation of these obligations today. So I speak with cognition here in the UK. There is a huge debate about what does it mean in practice to implement these obligations. And the general comment decisions like the recent Montana decision on the rights of children they're so important because they are pointing to the fact that there is a genuine gap here, an enormous gap that needs to be filled urgently, because as we all know, the future generations, the children, are the ones who will bear the brunt of this climate crisis. The obligations of states don't only concern the climate crisis, but they are particularly evident in the relation to the climate crisis. And this is why we all should really be pressing at every level for these obligations to be properly implemented and enforced. And I think this is a genuine gap that we've been overlooking for way too long.
Thank you very much, Annalisa. And since, would any of the other panelists want to come in on this specific question? No. All right. There's another question for you, Annalisa, actually, about the movements that's happening right now to request an advisory opinion from the African Court. And do you have any thoughts on the challenges and opportunities of this new advisory opinion? And maybe we link it to the Maastricht Principles as well.
So now the beauty and challenges of regional courts is that they operate within very different contexts, and therefore the guidance that they provide is context specific, and it's meant to be context specific. So clearly any questions that are brought before the African Court will rely on the instruments that the African Court can use in its advisory jurisdiction and in general be specific to the countries that are members of the African system. I think it's important that these questions are being asked. It's very important because the states that are members to these discrete systems need to be guided on what the implications of their existing obligations are vis-a-vis climate change. Like the children's rights question that was just asked, I think there has really been a deficiency of implementation and enforcement. Human rights, as we know, have huge potential vis-a-vis climate change, but this potential is yet to be fully tapped. So whatever instruments, whatever tool we can use, they are welcome. I know that there will be devil advocates out there saying, do we need all this advisory proceedings? I think that the answer is in the question, because if we are being asked questions, clearly we want to know. And we need to know, and we want to use every tool available in order to provide leadership on this question.
Thank you so much, Annalisa. Sir, go ahead.
Maybe just to complement this, one thing that I would flag is also that the ongoing advisory proceedings are a great moment to hold governments accountable in relation to the legal arguments that they are putting in front of these courts and tribunals. So the simple fact that governments are asked to justify actually how is it that you perceive that you, or how are you defining your legal obligations under the various international treaties that are being invoked, is forcing some of them to come up with arguments that clearly are not like legally rational and are just there to basically, well, act as the fig leaf to cover the absence of domestic policies on climate change. And I think that's a moment of transparency that we seldom have. And the more advisory proceedings we have, to some extent, the more we can have this conversation with governments about why is it so that they need to rely on fallacious procedural arguments rather than to embrace the fact that some of those treaties are very clear about the obligations of states, and we will all benefit if all state parties will implement their obligations in good faith.
Thanks very much, Seb. I realize we have about 5 minutes left in our discussion today. So just to give an opportunity to all of the panelists to come in one last time, if there are any last reflections you want to share on what kind of a role do you see the Maastricht Principles playing in these advisory opinions. I think Seb provided key insight on that, as all of you have done today. One thing I would mention, just as a process point, I think all of the panelists have tried their best to respond to all of the questions, but in case there are other questions, please feel free to reach out to any of us organizing the events, Camila in particular, and we will make sure to get back to you with a response. But just any last reflections, Aditi, Ashfaq, Fons, Annalisa, please come in, and thank you again so much for your very brilliant interventions. Please go ahead. Fons.
Yes, there was one question which was asked in the Q&A, which has not yet been addressed, and maybe it can be answered by either Anna Maria or Seb, and that is what would be the next steps in terms of advocacy for a better recognition of the Maastricht Principles within the UN human rights system, because both Anna Maria and Seb have been involved in this. Thank you.
Fantastic. Seb, I think you responded in writing, but do you want to come in?
Sure, absolutely. I think there are actually so many next steps potentially, because this is really not about one initiative going in one direction, but it's a clarification of a legal framework that all of us are using in our work, and governments, experts as well. And so there is no grand strategy on what is the next one step, but rather we hope that we can all work in synergies, and we invite you to reach out to try to not coordinate, but maybe just to exchange information about the various initiatives seeking to promote the integration of the principles in relevant UN processes. And so I named a few in the chat, but again, there is no one, you know, pulling the strings in the back, and we invite all of you to use the principles in your own engagement with relevant UN bodies so that we can have this integration, the promotion of the principles that are in the Maastricht Principles across the UN, so that they become more and more influential and really inform our interpretation of how human rights obligations apply. And so just to name a few, these advisory proceedings, and there it's very important to note that international courts normally are not really empowered to seek out their own source of information, and so it makes a tremendous difference if the principles are mentioned in submissions, in all interventions of the principle underpinning them, of course. So this is one avenue. Another one is the work of the Human Rights Council, its resolution, but also all of the reports of UN special rapporteurs, the work of the treaty bodies. The principles were shared with the Committee on the Rights of the Child in anticipation of the publication and finalization of the general comment. But of course, treaty bodies have also multiple ways of engaging. And there will be much that can be done. There is also an upcoming general comment of the Committee on Economic, Social and Cultural Rights on rights and sustainable development, where clearly these principles are so relevant. And then there is also a lot of developments happening in other non-human rights focused UN processes. I'll leave Anna Maria maybe to speak about New York, but even, for instance, when we think of UN climate negotiation, negotiation of a pandemic treaty, not only focusing on environmental matters, but also beyond, making sure that we do not treat intergenerational equity as just an empty concept that we add in preambles, but rather something that really means something in the legal framework, could have a tremendous impact. And if Anna Maria can complement on a very relevant entry point in New York, that would be wonderful.
Thank you very much, Seb. I am walking here to the Human Rights Council session. Your presentation was very good. I would just like to highlight that, of course, all the discussions around the Summit of the Future are huge. The Secretary General issued some briefing on the issue, but approaching it as solidarity with future generations. We think that this is not sufficient, and therefore we will be doing advocacy with states members to ensure that the principles are taken as a guidance for the summit. And as Annalisa said, the implementation of international human rights law happens at national law. I just wanted to share an experience even before the principles were adopted, but when we already had the drafts that we used for consultations, the Colombian parliament was changing its law on mining, and they invited us to have a hearing on how to apply the principles in this new legislation. How mining, and especially how interpreting the public utility, should be done on the light of the human rights of future generations. We hope that any one of you who is connected to judicial procedures, to legal procedures, to policy making, also becomes a champion of these human rights of future generations, and can help us to be part of the next steps. Thank you very much.
Thank you so much, Anna Maria. It was great to have the last word from you. Just very quickly to wrap up, we have another discussion on the same topic today in the afternoon, and please share the invitation with anyone that you think would be interested. We will share the recording shortly, as well as information about deadlines for submission of information to the various advisory proceedings, and we remain very interested in supporting government delegates in relation to any questions that they might have, including any of you from civil society that wishes to engage in these proceedings in any ways. Thank you so much for the exceptional presentations from our panelists, and thank you to all of you who joined us for this discussion today, and hopefully we can really center the rights of future generations across the advisory proceedings. Thank you very much also. With this, we will close the session today. All right.
Thank you.
Thank you.
Thank you, Joy.
Thank you.
So goodbye. Good day.
Goodbye. Thank you.